Breaking news, the South Carolina Real Estate Commission just released a 4-page statement on their website clarifying the controversial amended Real Estate Practice Act that was passed in May of 2024 that regulated the practice of wholesaling in the state of South Carolina. This statement by the REC clears up any misunderstandings and makes it crystal clear that there is no more wholesaling in South Carolina and gives the REC marching orders to enforce it. On this video, I'll break it down for you. If you don't know, in recent years, regulation in various forms has been sweeping across America. As of this recording, just in the past few years, 14 states have passed some form of regulation on the practice of wholesaling, including Illinois, Nebraska, Oklahoma, Arizona, Kentucky, North Dakota, Alabama, Oregon, Indiana, Wisconsin, Iowa, Virginia, Pennsylvania, and South Carolina. Now, I've covered all of these regulations here on my YouTube channel in detail. If you transact wholesaling in any of those states, it's your responsibility to learn and follow these laws where they apply. I put together and update regularly a free report with a breakdown of these different laws by state that you can download. Just go to wholesaleregulations.com. And of all these regulations so far, the state with the most aggressive regulation against wholesaling is South Carolina. In fact, South Carolina was the first state to ban the business of wholesaling in its entirety. Now, this is significant and alarming because I believe it opens the door and will pave the way for other states to follow suit. The South Carolina ban on wholesaling has also been the most controversial. When this bill was passed in May of 2024, I covered it extensively here on my YouTube channel. I even interviewed a member of the South Carolina Real Estate Commission, Gary Pickren, who explained the commission's position and intentions, which was to prohibit the practice of wholesaling. Now, since this law was passed, many took it seriously and stopped doing traditional wholesaling in South Carolina. Since South Carolina is an attorney state, most closing attorneys stopped performing wholesale transactions to avoid violating the law. However, some believed it was still okay, referencing nuances in the law like marketing a contract versus marketing a property, or taking certain aspects of the law out of context. Some wholesalers have continued transacting in the state. I'll talk more about that later. Now, I will say, why the South Carolina REC wasn't more direct and specific when they wrote and passed this law is beyond me. I mean, if you're gonna pass a law that says no more wholesaling, why not just make it plain and clear that there's no more wholesaling? But they didn't. That is, until now. Because of numerous inquiries regarding what you can and can't do, the South Carolina REC just came out with an advisory opinion letter clarifying the underlying meaning and interpretation of the Real Estate Practice Act. And this time, they left no rock unturned. They removed any and all ambiguity, and they made it crystal clear with no uncertain terms that the business of wholesaling is not allowed. And here's what you need to understand. The REC is the governing body with the power to interpret and enforce the statute. The REC is saying, this is how we interpret it, so don't do it. The investigative section of the REC essentially now has marching orders on how to investigate and enforce it, so you will see cease and desist orders and probably fines and penalties. So, for all you wholesalers in South Carolina who want to follow the law, even if you don't like it, pay attention. This letter released by the REC clarifies two things in the statute that were previously ambiguous. First, the difference between wholesaling as a business practice and doing an assignment of contract. And two, the difference between marketing a property for sale and marketing a contract for sale. Let's start with the difference between wholesaling and doing an assignment. In order to ban wholesaling, the REC had to first define wholesaling. Let's look at the exact word-for-word definition. It reads, having a contractual interest in purchasing residential real estate from a property owner, then marketing the property for sale to a different buyer prior to taking legal ownership of the property. Advertising or marketing real estate owned by another individual or entity with the expectation of compensation falls under the definition of broker and requires licensure. Wholesaling does not refer to the assigning or offering to assign a contractual right to purchase residential real estate. Now, that's a mouthful. If your eyes glazed over, don't worry. In this letter, the REC breaks down the definition of wholesaling as having four major characteristics or components. First, having a contractual interest in purchasing residential real estate from a property owner. Now, that's what we do as wholesalers. We contract to purchase real estate with a seller. The second component of the definition of wholesaling is marketing or advertising the property for sale prior to taking ownership. Now, we'll cover what marketing and advertising means, as well as the difference between marketing a property and marketing a contract. But one of the key aspects here is prior to taking ownership. That would include double closings and novations because you're marketing something you don't yet own. The third component of the definition of wholesaling is expecting compensation in the transaction. Now, this is a big one. Getting paid in the transaction is why we do it, to make money. Making money is what makes it a business. And the fourth component of the definition of wholesaling is using a legal instrument, such as another purchase and sale contract, an assignment, a novation, an LLC, or any legal instrument to transfer the interest to a third party for that compensation. So if there's any question as to whether or not you're wholesaling, go through the sniff test. Are you creating a contractual interest? Are you marketing or advertising it for sale prior to owning it? Are you expecting to get paid? And are you using a legal instrument to do it, such as an assignment? It's only wholesaling if it has all four components. That means doing an assignment in and of itself is not necessarily wholesaling. The REC letter gives a few examples of non-wholesaling assignments. A husband who assigns his contractual rights to his wife, or a sole member of an LLC assigns his contractual rights to a different LLC that he's also the sole member of. Those examples of assignments are not wholesaling. Why? Because it's missing the other components to be wholesaling. They're not marketing and advertising a property they don't yet own to a third party for compensation. The next clarification this letter addresses is the difference between marketing a property and marketing a contract. The South Carolina Code states, an advertisement that markets a contractual position to acquire real property from a person with either equitable interest or legal title and does not imply, suggest, or purport to sell, advertise, or market the underlying real property is permissible under this section. Now, when this law was passed, some people said, well, I'm not marketing a property, I'm marketing a contract so I can still wholesale. The REC clarifies this argument by stating that both parts of the clause must be present. In other words, you cannot market a contract for sale if it implies, suggests, or purports to sell the underlying real property. In other words, you can't say contract for sale when its contents of the offering is the property. The REC even lists 6 things that would be considered implying, suggesting, or purporting to sell the property. 1, a picture of the real property, land, or house. 2, a plat or survey of the property. 3, any description of the property, including the number of rooms, bedrooms, bathrooms, or square footage of the house. 4, the year the house was built or rehabilitated. 5, the condition of the property and its improvements. And 6, the address, tax map number, or whole or partial legal description of the property. In other words, you cannot give any indication whatsoever in the advertisement of the contract for sale that identifies a specific property. So how in the world can you market a real estate contract for sale without giving the details of the actual property? You can't, and that's the point. Do you see how brilliant the REC is? Sure, you can sell contracts, no problem. You just can't reveal that the contract is to purchase real property. They know what they're doing, and no one is going to buy a contract without knowing the contents of the contract. And just in case you're still trying to find a loophole with this law, and you're thinking, well, I just won't advertise or market the contract for sale. Nice try. The REC letter makes it clear that any effort to make the offering of the contract known to others constitutes advertising or marketing, including MLS, social media, print media, Facebook groups, private email groups, even verbal communication. That means any attempt at all to let someone else know you have a contract for sale that references at all the underlying property violates the provision of implying, suggesting, or purporting to sell, advertise, or market the underlying property. In this letter, the REC makes it crystal clear. Any legal instrument used to advertise, market, or sell a contractual interest on a property you don't yet own for compensation qualifies as wholesaling and is prohibited. And if you're pissed off about this, I get it. I am too. I don't like it either. I think this law is ridiculous. I think it's government overreach. I think it violates contract law. In the long run, I think it does more harm than good to sellers and the marketplace. I think it should be challenged and overturned. And I also believe this law and others are the result of our gross neglect as an industry. I've said it before and I'll say it again. It's our own damn fault. As a wholesaling industry, we should have been organized enough to fight these laws, and we should have stopped them or at least made an effort to stop them. We should have raised the bar with uniform standards of conduct and been self-policing to protect our own industry from the bad actors a long time ago. But we didn't. Y'all wanted to be a bunch of cowboys and do whatever the hell you wanted. Now we're reaping the consequences of sitting idly by as regulation steamrolls across the states. Having said that, just because you disagree with this law does not mean you are entitled to violate it. There is a process to fight unscrupulous laws. Laws can be challenged in the courts, overturned, and deemed unconstitutional, but you have to follow the right steps. Breaking the law or encouraging others to break the law because you either don't agree with it or because you think you can get away with it is still breaking the law. Don't be the very thing we are accused of, dishonest and unethical. Some of you have taken a catch me if you can approach. Your attitude is, as long as I can get away with it, it must be okay. That's like saying I robbed a bank and didn't get caught, so it must be okay. Breaking the law is breaking the law. Now, if you're a wholesaler not in South Carolina or another regulated state, my advice to you is to start preparing now. Regulation will eventually come to every state, and I believe in time, most states will follow South Carolina and ban the practice altogether. Now, I'm personally still wholesaling at a high level where it's still permissible, but I'm also not delusional as to what's happening in the industry. That's why I've been shifting my focus to a technique I call the takedown method. Now, the takedown method is where you find a distressed property, you contract to buy it at a discount, but then rather than marking it for sale prior to owning it, aka wholesaling, instead you get the funding and you buy it. Then, after taking ownership, you resell it on the open market for a profit. Yeah, good old-fashioned buy it at a discount and sell it for a profit. Now, to learn more about how you can do the takedown method, I did an entire masterclass series where I break it down in detail. I'll put the playlist link in the show notes below. The other thing I've been working on to pivot is a pilot program where I provide 100% funding to investors like you so you too can have the ability to buy those good deals. In fact, if you have a direct-to-seller contract at 70% of the current market value and you'd like to see if it qualifies for 100% funding, I'll put an application link in the description below. Now, one final thought that is really important, I think, to share with you is this ban on wholesaling in South Carolina and other regulations currently existing or new ones that will inevitably come, they don't matter in the slightest to me or other legit real estate investors. You know why? Because I'm an entrepreneur first. I'm a real estate investor first. I'm a wholesaler second. That means when one door closes, another one opens. That means I adapt to whatever's thrown at me. That means I'm willing to pivot and keep going. I will continue to make money and operate at a high level no matter what the market does, who's in office, or any regulations that are passed, because that's what winners do. If this law in South Carolina is enough to scare you away from the industry, good, go away. You should have never been here in the first place. You are the problem. For the rest of you, join me and let's navigate the rough waters together. Let's adapt and keep going. Let's find the ways to operate at a higher level. These regulations are nothing more than an opportunity to innovate, find better solutions, and provide more value and make more money. I, for one, am excited about the future because I'm paving my own way. You can come along for the ride or get lost in the background. The choice is yours.